Yes, sir.
Well, I guess one would not that failure to allow somebody to call the objector raise the issue of the constitutional right to cross-examine? And the second question, which is more procedural, is what is the scheduling for a weekend?
Okay. The question is, isn't there a right to basically cross-examine your objector? And the other second part of the question was, what about weekends? If I understand your first question correctly, then it is possible for you to call the objector as a party and to examine him. This comes up sometimes in the course of a preliminary motion alleging that the objection was not brought in good faith. Sometimes we, in the election law community, refer to it as shotgun objections. Yes. So if you make that allegation in a preliminary motion and the hearing officer deems it to be relevant and pertinent to that issue, it's possible to call the objector as a witness and examine him and pose questions as far as how that objector's petition was prepared. As far as your second question, on weekends, the schedule that we generally have in the rules sets Monday through Friday as working days of the board, but it allows the board to also work on weekends, Saturdays, Sundays, holidays, if we post notice. I can tell you right now that it's going to be posted up. We're going to be working weekends. The only day that our staff, well, this is really, I was going to say Thanksgiving, that's before the objections are filed. If we're not done by Christmas, we may give folks off on Christmas Day, all right? The board is really nice about that. But that's about it. Okay, Christmas, New Year's, if we're still going then. But we'll be working Saturdays and Sundays. Yes, ma'am.
So I wanted to know, is there a way that, because I live on a street instead of a place, and you all might send something registered mail, how am I knowing if I'm getting this? Can I call? And if I'm summoned to court, can I call every day? Can I check the internet? How am I to know? Because I don't want to get screwed up and miss an appearance.
Okay.
What do I do?
Okay. The question is, what do I do to make sure
That I'm accessible.
that you have been objected to and
Yeah.
what you're required to do going forward? We will mail the call to the address that is listed on your nomination papers, and that is the address where we will direct the sheriff to go out and serve. Now, if you're a candidate, and I'm sure you're all going to be, all you candidates are going to be wondering, okay, have I been objected to? It's real easy. We're going to be, as soon as those objections come in, we're going to be preparing a list, a master list of all the objections, and that will identify the objector's name, the candidate's name, and we'll be given a case number.
I've seen it online before.
Right, and that goes up pretty quick, and that's all online.
Yes.
So you will know relatively soon, certainly within the first 48 hours, if not the first 24, whether or not your nomination papers have been objected to. If you have any questions as far as what the schedule is going to be, you can call the board. There's a number in the sample rules that you have there. You can call and you can ask. Okay. Now, we may not have the hearing schedule posted up right away. That usually takes a couple of days to work out. But don't be afraid to call the board and ask questions, and we'll provide you with whatever information we can.
I've been calling you since March. I'm not afraid.
Okay, good. Yes, ma'am.
Is there a similar kind of system for the actual filing of petitions where you have a master list that's available online? Because during that window, we won't, unless we're sitting there,
Right.
we won't know.
The question is there a similar list with a master list of all the candidates' names who file petitions? And the answer is yes. And that also will be posted up on the board's website. Yes, sir.
Can a candidate be challenged by multiple opponents?
Yes. I'm sorry. The question was, can a candidate be challenged by multiple objectors, multiple individuals? And the answer is yes. Yes, they can. Yes, sir.
Are all those or they all like handled at the same time, or are they handled separately? Yeah.
The question is if they file multiple objections, are they all handled at the same time? And the answer is depends. If there are common issues of fact and law, then they may be consolidated for hearing on that question. If they're separate issues, they can have separate hearings on it. If you have, let's say, for example, two objectors, they've both challenged individual signatures. Typically, they'll file what's called an appendix hyphen recapitulation, which is basically sort of an index of all of the sheet and line numbers where they're objecting to your signatures. We treat those differently. We don't consolidate those. We may do the record examination at the same time if it's efficient for that purpose, but each one is reported separately. So you can't, the objectors can't gang up and consolidate their signature objections into one challenge. They're treated separately, the results will be separately, and they each stand on their own. Yes, ma'am.
Do the objectors have to have reasonable cause to believe that the signature is not the same before they can make that, before they can object?
Well, they can make the objection that on a genuineness of signature, that the signature is not genuine. What grounds they make that on, it varies. Most often, it's because they have come into the board, they've reviewed the board's voter registration database, and in that database, we have a representation, an electronic digitization of that signature. And most often, the objectors are in the board upstairs on the 6th floor, they're going through our database, they're examining the signatures on a petition, and that's how they draft their objector's petition. They make a decision that, in the opinion of whoever is preparing it, that the signature is not genuine. Do they have to have any scientific proof of that, or expert testimony or proof at that point? No. Sometimes they may have some other basis on which to make the objection. We don't know. But there are, and you find this in the index of Electoral Board Decisions on the category of shotgun objections. Sometimes you'll have an objector's petition that has an appendix recapitulation, which again goes down and lists all the sheets, or lists the sheets that they're objecting to with the line numbers they're objecting to. And we've had cases where every single line and every single sheet has been objected to on every conceivable grounds. Those are fairly easy to dispose of, and because it's hard to imagine that someone exercised a good faith due diligence effort to find out if there was some cause upon which to make the objection. I'm not saying it can't happen, but it's highly suspicious in that kind of a situation. And so what they do then in that kind of a case is they say, well, okay, we're going to send this to a sample records examination, and we're going to test maybe 2 signatures on every sheet. So it's a sample, and they'll send it to a records examination, and based on that result, the hearing officer may get a result back which shows that the majority of those objections had no basis, and they were overruled. And it's up to the hearing officer to decide, based upon any partial record examination results or any argument or evidence presented by the parties, whether or not that objector's petition was filed in good faith. And if it wasn't, they will throw it out. Yes, sir.
I have a 2-part question. Question number 1 is, what are the financial requirements to file an objection? And number 2 is, for the candidates, what kind of dollar amount would someone be expecting to spend to defend a challenge?
The question was 2-part. I think the first part is what are the monetary requirements to file an objection petition? And the second part of the question is how much would you expect it to cost for a candidate to defend against an objection petition? There's no filing fee for an objection petition. So anyone can file an objection petition if they're eligible to do so. They're not required to pay a fee. We're a nonprofit board here, so it'd be great if we could charge a fee and make a profit on this, but I might put that on the legislative agenda next time we can get that done. But right now, there's no monetary requirement. As far as what it's going to cost to defend, I can't tell you that. I don't know. Some of these things get resolved very, very quickly. Some objectors withdraw their objections even before the first hearing. Others drag out, and it can get very complex and drag out for quite a long time, in which case it might be more expensive for a candidate to defend himself or herself, especially if they have an attorney who's charging them by the hour. So I don't have an answer for that. Sorry. Yes, sir.
I have two-part question as well. First, I have a very sloppy signature, and so what if both signatures, as long as they match, or is it okay, or is it, if it's illegible, is it like disqualified?
The answer is about signature comparison, and if the handwriting is sloppy or illegible, is that going to affect the validity of the signature? The process is that during the records examination, and we're going to be getting into that next, during the records examination, a board clerk will take the objector's petition and they will go through every sheet and line, and there are a number of reasons under which a particular signature can be challenged, but one of them is that it's not genuine. What happens in that case is that the board clerk will then make a comparison of the signature on the petition to the signature that's on the voter registration record. And they will then make a decision, a determination, as to whether or not there's a match. Now, just because there's sloppy handwriting doesn't necessarily mean the signature is not genuine. But if the board employee cannot make a reasonable match to the signature in the voter registration database, then the objection is going to be sustained. Now, we understand that over the course of time, people's handwriting changes. And you have to take that into account, and our employees are instructed on that as to how to take that into account. But if they do not believe that there's a reasonable basis to find that the signature is made by the same person, they will sustain the objection, meaning the signature is invalid. You have the right under Rule 8 to file an appeal and have that issue determined by a hearing officer. And there are a couple of ways you can bring evidence in, one of which, of course, is you can ask the individual who signed the petition to come forward and testify, yes, that is my signature. I fixed that signature or my signature on sheet 1, line 1. Another way that we allow that issue to be tested is by means of affidavit. If you can get an affidavit that's in proper form and signed by the voter, and that affidavit establishes sufficient basis upon which to conclude that, yes, I signed John Doe's candidate petition at sheet 1, line 1, excuse me, and that is my signature, and I intended to sign that petition for John Doe. If that affidavit is in proper form, the hearing officer can accept that as evidence. So there are ways to come back and what they call restore that particular signature.